Welcome to this event, which is the actually last event in this academic year, hosted by the Centre for the Study of Governance and Society. I'm Mark Pennington, I'm the director of the centre, and I'm also the head of the Department of Political Economy here at King's. I'd like to recognise support to the King's Worldwide Partnership Fund, which is supporting the event this evening. We're delighted for this final event of the academic year to have with us Professor Gary Cox. Gary is Professor of Political Science at Stanford University, and he's one of the world's leading authorities on legislative politics, bargaining theories, electoral politics, and I would say more generally in the application of economic approaches to understanding political phenomena, the political economy of institutions and decisions broadly understood. He's the author of, among other books, Making Votes Count, The Efficient Secret, Legislative Leviathan, and most recently, Marketing Sovereign Promises. Tonight, he's going to speak to us about patent disclosure and England's Industrial Revolution. So please welcome Professor Gary Cox.
Thank you. So I was trying to remember where this topic began, and I think it was in a wine bar with Doug North, who recounted to me his ideas about patenting. And in a very rough form, with all nuance discarded, this was his argument that after the Glorious Revolution, England's patent system, which had been put on a formalized basis since 1624, existed previously, but formalized then, offered more secure intellectual property rights, and the consequence is more inventive activity. So the metaphorical wave of gadgets that emerged and constituted the Industrial Revolution. So a picture of the relevant events, somewhat consistent with his story, is just the patent series. These are the number of patents sealed in each year in England. And you can see shortly, right around one of the many possible starting dates for the Industrial Revolution, 1760, we get this beginning of basically exponential growth in the number of patents per year. So that basic plot had been known for a while, and then we get to the case against the thesis. So before 1851, the costs of patenting are quite high, maybe north of 120 pounds, and that's in 18th century pounds. And so, as a number of people have pointed out, the costs were so high that only a tiny minority could have been motivated to undertake some sort of inventive activity by the thought that, and then I'll patent it. Then I'll bear ruinously high costs to patent it. Is a big inducement. Another statistic which is commonly tossed about to point out how little influence, or to minimize the influence of the patent system, is from a paper by Petra Moser, where she looked at all the Crystal Palace exhibitions, I believe that had to do with an invention of one kind or another, and traced down whether each had been patented or not, and only 11% had been of the British exhibits. So the current conventional wisdom is pretty significantly different than North's. So Mulcair points out that, or states that the importance of the patent system in the British Industrial Revolution has to be scaled down from its Northian heights. No evidence supports North's position, according to Gregory Clark, and it is doubtful Britain would have seen less inventive activity had it lacked a patent system, MacLeod and Nuvolari. It's this last formulation which I think is the most interesting because it really gets to the crucial counterfactual. You know, would anything have changed if you imagine the alternative in which the patent system had never been formalized in the way it was in England? So both North and other early proponents of the idea that the patent system had some effect focus on what I'll call the incentive effect of the patent system. How does it alter the incentive to undertake R&D or inventive activity? And much less, very little attention has been paid to what I'll call the disclosure effect, which is essentially to the extent that patents are disclosed and not kept secret, as they might have been in an era with no patents, does the revelation of that information have any impact on the R&D community? So in particular, I'm going to look at a relatively obscure reform of the patent system in 1734, which required patentees to submit technical specifications for their inventions, which were then made publicly available for a fee in Chancery Lane, London. So prior to this time, there were very few specifications. There were a handful of inventors who would voluntarily specify their inventions. And then there were a relative handful who were specifically required by the Solicitor General or the Attorney General, the two main officials at this time who were the main actors in granting patents. But in 1734, the law officers saw fit to make this a regular requirement. And we'll see later that compliance was fairly good with this new requirement. And a whole bunch of technical specifications began to pile up, trickle in, let's say, in the early years, since the number of patents is still pretty small. Trickle in and then eventually pile up later in the century. So I'm going to talk about how patent disclosure might, in theory, have stimulated R&D. Then we'll pivot over to some evidence that it did stimulate R&D, and then talk about sort of the broader debate over the patent system and preconditions that existed in England and Britain at this time that might have magnified this sort of reform effect. The running metaphor, or at least a metaphor to put in mind, is a new journal is announced, and you're interested in things technological, and it's the only journal, in fact. And it has a lot of really bad articles in it, but there are some gems. Do you subscribe to the journal or not? We'll see. Unfortunately, I can't answer any of those questions with diaries and direct evidence, but we'll be looking at indirect evidence. So here's how disclosure could have stimulated, should have stimulated R&D. So first off, it provided the means to undertake research because some specifications conveyed scarce technical information. If you were to read Lewis Paul's specification in 1738, you would learn the basic principles of roller pins in textile machinery. If you read Jonathan Hull's 1736 specification, which he also published as a standalone pamphlet and book, you would have learned the basic principle of a steam tugboat and a fairly detailed specification of his effort to mount a Newcomen steam engine on the back of a boat and propel it. It didn't work very well. It wasn't a particularly good design, but the principle was certainly conveyed. Specifications also meant better access to information, and this can both lower your research costs, anticipated research costs, and possibly raise your chance of success. And both of these things should affect your motive to undertake research. As we'll see, the reform had a more strong, probably a stronger negative effect on incentives to patent than this one on incentives to undertake research. Each new specification also provided some immediate opportunity to search for complementary or perhaps substitute inventions. Complementarity is what I'll emphasize most. Every sector of the economy has some Cobb-Douglas production function in a stylized fashion cranking away, and a Cobb-Douglas function has a series of inputs which multiply together with coefficients, and that's a picture of complementarity I want you to have. So as soon as somebody improves one component in a long production chain, the value of improving any other component in that chain goes up. So David Landis and various other people have pointed this out. So each new specification, were it to become known, either directly or through conversation with somebody who did see the specification, might jog ideas in an inventor's mind about other aspects. So Lewis Paul, again, once you've improved that part of the textile industry, and this of course was Landis's main example, then you want the spinning of the yarn to be improved, and the next generation of that kind of machine, and so forth and so on. All right, so that's the basic argument. Those of you who know the existing literature on the patent system will perhaps have already anticipated some of the objections, and I'll run through just a few of them. So many specifications described worthless inventions or obfuscated worthwhile inventions. So there's a large number of worthless inventions in the patent series, many patent medicines that appear not to cure anything. You're, I think, free to go and try to reinvent them and see if, make the test yourself. But many other perpetual motion machines that probably don't work, and so forth and so on. So a specification of an inherently worthless invention, one might think, is not particularly valuable, and access to it can't be worth much. And then there's another sector of the literature which points out that patentees of worthwhile inventions sometimes would file obfuscatory specifications rather than revelatory specifications. So the answer I give to this is to grant that there were many worthless inventions and some portion of purposely obfuscatory specifications, and just point out that there was a significant share of upper tail inventions which had informative specifications. So if we go back to our metaphor of a new technical journal coming out, the bad news is it has lots of bad articles. The good news is there are some good articles and there's nowhere else to get them. So the amount of new information that's becoming publicly available to the inventing community, in principle, is going up. So the picture here doesn't require you to think in terms of the average inventions effect, but our statistics, of course, will be looking for averages. My belief is that if they are meaningful, it's the star inventions that are doing most of the work. And indeed, when you rerun some of these analyses, trying to identify the star patents, the results still hold. But here we'll be looking at the entire array. So another potential objection, or actually objection one sees in the literature, is that inventors had to pay fees to view specifications and bear search costs in what were disorganized 18th century archives. There were 3 different offices in which the specifications could be filed. The clerks didn't have an index, and so forth. By the 19th century, by the time of the reform in 1852, these were significant search costs. We've got quite a large number of patents by now, so there's a variety of patent agents and inventors testifying before parliamentary committees that it's a pain and it's a chore and it impedes their research and so forth and so on. In 1734, the total number of patents that had specifications was that had been voluntarily filed and so forth and so on is maybe a dozen or so. And you're adding 1 or 2 or 3 per year to that. So at that time, the search costs are not particularly daunting, even lacking indices. Plus, most of the specifications were filed in Rolls Chapel because they had lower fees. So you don't have terrifically bad search costs. But the main answer to this point is, again, to say, yes, you had to pay fees to view specification, and yes, you bore search costs, but compared to the system that existed beforehand, your costs of searching for technical information simply went down. Prior to this reform, the main way of learning about an invention was to get in your horse buggy and go out and personally visit the guy who invented whatever it was, or write him letters and ask him questions and hope for a reply. Both of those technologies still existed after the reform, and in addition, you could just go to Chancery Lane and look at his specification. So it simply added a resource. And I also point out that many people chose to bear these costs. The data, the evidence for this is very poor for 1734 and 5, but it's quite good a century later. You can see the total amount of fees paid. You can listen to the testimony in front of these committees and so forth. And it's quite clear that there's a steady stream of people coming in and using these specifications a century later. So what I'm going to focus on is what I'll call the metropolitan advantage. It's very difficult to get round in the 18th century. The reform is passed before the big wave of turnpike road construction in the 1750s, so it's even more expensive. Even after that, it's still expensive. And so the idea that a provincial inventor from Nottinghamshire would say, I'm going to go down to London to look at the specifications that were filed doesn't make a great deal of sense. They would have to be extremely confident that the specification contained very valuable information to cover the costs of traveling and staying overnight in London and then going back. But for the London inventors, it's not such a big deal to walk over to Chancery Lane and take a look. So if we think, so the provincial inventors should not particularly have benefited from this new library of specifications. The Londoners should benefit primarily by learning about what the provincials are doing, or the Germans or the Americans. They can already know what each other is doing just by talking to each other and visiting. So the primary new sort of stimulus to inventive activity is London inventors' access to provincial inventions. So what's the evidence of any kind of disclosure effect? So I'm going to talk about London's per capita patenting rate, and this will just show you a simple patents per million sealed by Londoners in 1735 minus patents per million sealed by any other English person in that same year, so regardless of their residence. Excluded are the Scots, the Irish, the Americans, and the Continentals. They don't get counted. London here means the City of London, Ossleton 100, Tottenham, and Surrey on the Thames. And this is roughly take Chancery Lane and draw a big circle. But it's also roughly what contemporaries considered London or metropolitan area to be. So here's the basic picture of that difference. So you can view this as a difference in difference in the sense that each year is already difference between London and the rest of England. And the two curves are Loess lines, one prior to the reform and one after. And the picture you're supposed to see is that it's a noisy series, but there's no trend in the gap. Londoners are producing about 4 or 5 patents per million more than all the rest of England aggregated. But there's no trend. They're not becoming more productive relative to the rest of England. After the reform, you see what might be a drop, and then a clear upward trend, which is practically linear from reform on. So we can look at the picture. We can also test for a break. One way is just to run a regression where we allow, we look at the trend allow the trend to change in 1734. There's no significant pre-reform trend. There's a positive and significant post-reform trend. Another way would be to use an agnostic test and search for an unknown break. Don't pre-specify when the series breaks, and just ask, here it's a supremum Wallet test, is there a break? If so, where is it? And that test says 1732 is the point at which we get the change. If you stare at the plot there, you do see that really is the minimum. A couple years before the reform. For my purposes, I consider that close enough to support the idea that the reform had some effect. Another way of thinking about the comparison is not to compare London to all the rest of England, but to compare it to the top 10 provincial towns in terms of patenting. And that turns out to be Birmingham, Bristol, Chatham, Coventry, Hull, Leeds, Liverpool, Manchester, Reading, and Sunderland. So these are the top 10 towns prior to the reform. And we can do the same thing. Again, we get a noisy series. Here you see it's centered around 0. These, if we viewed these 10 provincial towns as if they were one entity, they're about as productive in terms of patenting as London was. And if there is a trend, it's downward. And then after the reform, we get a upward trend. You can do structural break tests again on that. So that's the first sort of kind of evidence that something happens. It perhaps is not due to the reform of 1734, but we can be reasonably sure that something happened around that time that causes London for the first time to begin to outpace, to diverge from either the rest of England writ large or the rest of urban England. So there's a puzzle, at least, to be addressed. The argument here is that the reason for that particular time of change is this reform. Okay, so statistically, the divergence here that we see, or the action, is pretty different than the first picture I showed you, which was the total patent series. And structural break tests have been done on that series as well. And the answer as to when the break occurs is 1756, or thereabouts. So there's a much longer, more gradual period, and then the trend starts up significantly just before the Industrial Revolution. Here, the finding is a little bit different. We're not looking at the total patents. We're looking at whether London is outproducing the rest of England. Going back again to the idea, it's only Londoners who are treated, so to speak. Only they have some privileged access to new technological information, and only they appear to be responding. So that's that second bullet, that we can view this roughly as a difference in differences analysis. So is there evidence then that the patent specifications actually have some sort of statistical relationship or otherwise mediated the apparent response? So we see a change in London patenting rates, which is consistent with them having some sort of new access to technical information. Can we relate it specifically to the patents that are supposed to be doing the trick, which is patents by non-metropolitan inventors, which are specified? So actually, before we get to that, looks like this is a replay of the pictures just running panel regressions. So the dependent variable is the patent secured by patentees residing in a particular county in a particular year. There's a full set of county fixed effects, year fixed effects, and there are county-specific trends. I should say, if you just stop with those three, you fit the data reasonably well for a fair number of counties. For example, some counties have a patent series of 0 all through the period that I'm going to examine. That period being from the Restoration to 1760. So most of my analyses go 1660 to 1760 or 1660 to 1780. Those periods chosen so that it's before the Industrial Revolution. I want to look at patenting before the Industrial Revolution. So county fixed effects, year fixed effects, and county-specific trends do a pretty good job of modeling the basic trends in most counties. On top of that, we have county population. This is interpolated since we get population readings at fairly infrequent intervals at this time period. A post-1734 dummy, lag number of local patents. We would expect persistence in patenting in the sense that if I patent and I'm in Kent, the other Kentish potential inventors probably hear about it or can hear about it. They can draw inspiration from it. It's not such a big deal for them to visit me. And so we expect some sort of inspirational response to local patenting in each county. And then we also are going to include the lag number of non-local patents. And this is what we're going to allow the coefficient to shift pre to post 1734, and also between London and the rest of England. And so the summary just takes the estimated effect of non-local patents in various places and time periods. So top left, for example, is non-metropolitan England in pre-reform times. The average sort of partial correlation after controlling for all the rest of the regressors is negative and insignificant. If we continue in the top row over to the right column, we see that non-metropolitan England after the reform has a small and insignificant positive response to non-local patents. In the bottom row, we see metropolitan England, i.e. London. Prior to the reform, they're already responding somewhat more to non-local patents, and post-reform, that response goes up considerably. The difference there is statistically significant. So this is basically just retelling that story of the graphs, but with various possible confounders controlled. And so we get this conclusion. London patenting became more sensitive to non-metropolitan patents after the reform, as it should have done under the hypothesis. So before I get to this, I will say that another part of the analysis, which I didn't put on the slides but will describe briefly, attempts to connect counts up the non-local patents that come into London that were not specified, and the non-local patents that come into London that were specified, and takes those as separate possible stimuli to London patenting, and runs them. And of course, the hypothesis should be that a non-local patent that's not specified is not particularly accessible to London inventors and shouldn't produce much of a response in their own invention in the next year, whereas the specified stuff can. And that analysis also shows the expected results. So what are the pre-reform conditions that could enhance patent disclosure? I want to lay out some of these as they sort of affect the plausibility of the idea. So metaphorically speaking, there was a certain amount of tinder lying about. High wages and cheap coal was one possible idea about sort of latent motivations to invent in England vis-a-vis elsewhere. That's Bob Allen's idea. The scientific revolution, an improving mentality, sort of general ideational changes in Europe and specifically in Britain. And then something that I put a fair amount of emphasis on in the paper, which I think largely connects to the first 2 points, also are what I'll call strategic complementarities in R&D. All of you should have had some, at least if you remember when you were a young academic, you would have some familiarity with this, which is work on something that a bunch of other people are working on other parts of, because they'll cite you as an integral part of this larger academic process or project that's being undertaken. Work on something that no one else is working on, and explain to your dean that nonetheless, this is really the best in the cohort. So complementarities in economic terms would mean things like Wilkinson doesn't work on precision milled cylinders until there's a good enough steam engine to make precision milling of cylinders the bottleneck in further improvements in the efficiency of the machine. So that's another sort of Landis kind of story, but there are many examples where it should be clear, and arguably was clear to inventors, that if those guys over there succeed in doing what they claim they are doing, my invention will become more valuable. Therefore, my expected profit goes up for staying the course and putting some more effort into my research activities. Pretty much all production processes have these sort of latent strategic complementarities in them, and the more specialization, so just back to a Smithian specialization and ideas about the English economy expanding and integrating, all of that should increase these strategic complementarity incentives. One thing to say about at least the last two is that they are, in a sense, England-wide or Britain-wide. I mean, these ideas could be potentially accessed and recognized quite widely. High wages and cheap coal could be perhaps more naturally localized. But nonetheless, if you thought that that was an important reason that British inventors were seeking inventions, you could probably do that on the Isle of Wight, even if you weren't particularly near a coal field. I hope there isn't a coal field in the Isle of Wight. I'm assuming there isn't. And you could sell your rights and make out profitably. So you don't need to be literally sitting on top of the coal in order to have the effect. So this various different kinds of tinder ideas out there that should have helped potentially promote inventive activity. And then here, the spark that's being highlighted is patent disclosure. And it's significant, I think, because there's a quite low voluntary disclosure rate prior to the requirement. And there's very little in the way of technical journals and periodicals and libraries disseminating competing information. There's the transactions of the Royal Society, but there's not a lot in those of the kind of sort of hands-on description of technology that you see in the specifications. And the actual technical journals are all much later in the century, 1780s, 90s, mechanics journal and things like that begin to come in. So it really is an unusual resource for the time. So some other effects. The reform imposed a substantial new cost on patentees, that of preparing a technical specification. They didn't have to do that before. So you have to write the research paper. That's a cost of some sort. And by the 1830s, we can quantify it, and it's about 28% of total patented costs. This is before the 1852 reform. So by the 1830s, inventors are taking the requirement pretty seriously in terms of cost outlays, at least. So what should we expect? A new cost should depress the patenting rate, the percent of inventions patented, and increase the quality of inventions patented. This sort of hypothesis has already been undertaken for later patent reforms which cut costs, where you just flip the predictions and found to work out. So I looked at it here as well. So as far as the depressed patenting rate goes, we only have the indirect evidence that if you remember the graphs, they show a kink down roughly around the reform. And the coefficient on the post-1734 dummy is negative and significant. Somewhat more, much higher octane, better evidence concerns the second, which is the increased quality of patents. So this is from Woodcroft's reference index. At the time of the patent reform in 1852, they commissioned Woodcroft to compile a comprehensive list and indexing of all patents from 1617 on to 1852, which he did with a small army of clerks. And one of the things they did is search through 114 distinct sources, technological journals and law and legal commentaries, for any reference to any patent, and then sort it out to which patent. And so for every patent from 1617 on, Woodcroft lists we'll call a reference index. It's the number of references that they found to this particular patent. And Nuvolari and Tartari have a paper where they sort of extensively look at whether or not one can take references as a guide to quality, as a proxy for quality. And they conclude that you can. I'm relying on that finding here, so it's somewhat similar to patent citations in a modern case, but a bit different. And here's what you find if you simply graph the mean number of references received by all patents in each year. And what you see again is a noisy pre-reform trend, which is approximately flat at 0, a little bit above on average. And it jumps up to something north of 1.5 and wobbles around. So prior to the reform, it's rare to get sort of bestsellers that hog a lot of references. After the reform, some of the ones I've mentioned, like Hull and Paul, get a fair number of references in the literature. So this is consistent with inventors having a response to the new reform insofar as its costs are concerned and as it affects their incentive to invent. Of course, that doesn't prove that the disclosure effect was also important, but the other simultaneous changes that speak to the disclosure effect, the disjuncture of London from the rest of England mainly, suggests that that's what's going on. So we have a reform of 1734, coincides with a number of discontinuities. There's a step down in the patenting rate, which makes sense if there's higher costs. There's a step up in the quality of patents sealed, which makes sense, again, if there are higher costs. And there's an increase in London's per capita patenting rate relative to the rest of England, which makes sense if Londoners have basically unique access to a particular resource, which is learning about what these Birmingham inventors are doing and the Manchester inventors and so forth as they since now those inventors have to tell them, or at least at law have to tell them. So London's divergence appears to have been mediated by increased responsiveness to non-local but specified patents. And cumulatively, the conclusion I reach from this undertaking is that patent disclosure was, the way I would put it, is another in a constellation of factors that are accumulating in the 18th century that simultaneously improve the flow of information in the relevant community. If we think of scholarship in general as a community activity that requires some communication and benefits from that, that's the disclosure side, but also affecting the many factors that are accumulating to increase the incentive to invent. I think the Reform of 1734 is relatively a small story on the incentive side. It had some pluses and some temporary minuses, and a somewhat larger story on the disclosure side. So I'll end there.
Which territories did the patents that you're talking about apply to, and how were they defended?
So the English, so the inventors had their choice. They could patent in England, Scotland, and Ireland. And many of them would do at least England and Scotland later in the century. But you did have to pay additional fees in all three kingdoms. So you also get a certain number that are England only, a very small number that are only Scotland or only Ireland. So once you've got your patent protections, you have to defend your rights, be prepared to defend them. And so another part of the patent literature is a debate over how defensible patent rights were, whether they were successfully defended or not, and when they became at law consistent with the story I'm telling here. So the typical story in the current literature is that patent disclosure and what's called the patent bargain, the idea that the point of a patent is to divulge the mechanism by which the invention works in exchange for your 14 years of monopoly. Everyone agrees that that's the way the English view it as a matter of law by Lord Mansfield's decision in 1778, I believe. And the debate is whether some, like Sean Bottomley, argue it's true pretty much back to the 1730s, and others that it's not true until you get this precedent. I tend to side more with Bottomley. I quote something from a newspaper which clearly articulates it as a principle. I can't prove that it's Lord Mansfield or anybody in position of power, but it seems to be an idea that's out there in the public domain, that this is what a patent is. It's you get your 14 years of monopoly because you are going to reveal how to work the process. So as to how much patent rights were defensible, I tend to think that I can be pretty agnostic on that. That's something that affects the incentive effect of the patent system. If you go to the extreme and say, well, they were completely indefensible, therefore worthless, you do have a puzzle as to why you have an exponential growth in the number of people willing to throw away 120 pounds on obviously worthless rights. But within a normal or more plausible range of disagreement on the defensibility or non-defensibility of these patent rights and how fast they become defensible, I think the logic of my argument is fairly immune from that, because all those events are occurring after the sort of breaks that I'm finding. So they're 1750s on.
Hi, Gary. I guess my major question is, where does the reform come from? Are there people pushing for this? Is this, from what I recall, this is a kind of bureaucratic procedural change more than it is a legal change? Because, I mean, other than the 1852 law and the original 1624 statute, there isn't much in the way of legislation. But are there particular individuals who are pushing for this? And if so, who are they?
Yeah. So MacLeod tells a story that it's the Thomas Loam statute, which 1732, which confers extended patent rights on Thomas Loam by statute in exchange for him fully disclosing the invention via a deposit of the machine itself in a public institution. Tower of London. Yeah, Tower of London. Although not as popular as the Crown Jewels, as something to visit, as far as I understand. So if that's true, then we know a little bit about the motivation, which is the Republic of Letters, the scientific revolution. That idea had percolated far enough into Parliament to get this statute, and then the law officer said, well, we're going to do that. It would be great. I did look around in the available documents, and it remains a pretty obscure reform in terms of being able to document who thought of it, why they, any sort of detailed documentation. I'm not sure why MacLeod even said that, or whether she simply noticed the conjunction in time and thought it was plausible, or whether there was some additional basis to think that. But my preferred account is that it is it's a precipitate of the scientific revolution or the improving mentality, and it gets into enough thing, and it takes a very concrete form at this point. And what it does is that it forces all the inventors who had not internalized these norms of open disclosure and free dissemination of knowledge to comply nonetheless. And that was important.
It's a very persuasive set of pieces of evidence, but I wanted to press you a little bit on whether we can be quite so sure about the timing in the general patent time series, that definitely does come later, because in some sense it's possible to explain these differences between particularly London and non-London areas simply by a general takeoff, and because of agglomeration effects being bigger in the bigger centre, then it means London takes off more than do the smaller centres for those simple reasons. And so I wanted to press you a bit about whether we know the takeoff point is definitely later. And I suppose it's not just that, in a sense, these are always tricky things to identify, but I suppose it would be also quite important to know that the time series for patenting amongst Londoners has a later takeoff date, because that's the series for all patents. And it's important, I think, for your story that you should be able to say the same about 1756 for the patents that are associated with Londoners.
So I compute the capital stock of non-metropolitan patents with specifications. So You know how many there are each year. Think of it as a book, and it depreciates at 15% per year, let's say. So now I can graph the cumulative capital stock. It could depreciate if there aren't a lot. You could also weight that by importance, so that something like Lewis Paul's invention would count twice as much as there weren't very many patent medicines from the provinces, as I recall. You can look at that graph. That graph should should lead London patenting increase. And that does a very good job. If you use that instead of the 1 year lag of non-London specifications. That doesn't quite answer your question, but it's how I've been thinking about that. Probably the answer is, though, the agnostic tests do work out. At 1756, sort of staring at the graph, it's a little bit dicier once you have in mind that there could have been, this earlier increase. And basic agglomeration economies is something that I've just, the only way I can control for that are year effects and county-specific trends and things of that sort, and the population, of course, which you do have pretty well. The other thing I can say in that, which causes me to discount agglomeration effects per se, is that London was hugely bigger than all these 10 provincial towns from 1660 on. And the gap in sheer population, and if we can take that as a proxy for all the agglomeration effects, is growing and growing. And then all of a sudden in 1734, it finally has its effect. So if we knew more about the precise mechanisms of agglomeration, then possibly we could take another whack at it.
So the question that I had for you, are you arguing that there is an increase in the number of inventors that are proposing new inventions? Or are you seeing this as a pattern that's being driven by economic actors that are, in a sense, free riding off of the knowledge advances that are being made by inventors? And I guess the reason I ask this question is that when we think about people that come up with new inventions, oftentimes these are people that are not sort of part of normal corporations. They're sort of a unique and unusual breed of entrepreneurs that are perhaps less sensitive to simple economic factors, but are more interested in just sort of pursuing the thrill of invention. And I guess I was wondering if you have any sense of whether or not this pattern is being driven by a quantitative increase in the total number of inventors that exist, or whether or not what's going on here is that normal economic actors are essentially free riding off of the knowledge that is being made available by this unique and sort of small group of people that are producing new ideas.
Right. So I can tell you that the number of inventors definitely goes up. Also, the number of inventions per patentee goes up. And my interpretation is that it's possible to imagine invention as a profession. It becomes more and more possible to, think that way. And there's a lot of people who sort of undertake that new profession. They may keep their warehouse and still be doing things, Watt and so forth, but you definitely see, you don't, in the 17th century, one and out is a very common, that's the mode. It might still be the mode in the 18th century, but there's an increasing share of inventors who are multiple inventors and sometimes many inventions. so you get, if you take those as the big economic actors who are seeking to exploit, you get that, and then you also get a large run-up in the number of smaller inventors. So my picture is that both of those things are happening. That smaller inventors are, there's more people inventing. It's hard to think that they would be inventing because they think the patent process is going to be really valuable for them, because a lot of these are small and small people without the capital means. But it's easier to think that they're being inspired by access to information. And so one thing I did think of trying to look for, but don't really have the data, is whether the if access to information is the important thing, then we should find that access to specifications should stimulate all kinds of invention. So if we had other mechanisms to measure inventive activity, we would expect to find a hit there as well. So in an earlier version of the paper, I did include data on Royal Society of Arts premia, which are awarded to non-patenting inventors. And the basic finding was there's not a lot of those data. It's only about a decade. It's not always possible to geolocate them and so forth. But the basic finding was this: accessible patents, which could either mean local patents in your own county where you can personally visit, or non-local patents that have a local specification, predict premia. But the reverse isn't true. So a county that has a bumper crop of Royal Society of Arts premia doesn't then in the next year have increased patenting. So those are the basic statistical findings. That's another way of thinking that it's a disclosure effect, broadly increasing the inventive activity, presumably through a disclosure effect, not an incentive effect.
Thank you so much. This is a very interesting sort of data to assess the effect of sort of changes in patent regulations for creativity and innovation. And so I was just wondering if you are willing to draw more general conclusions about patents, the role of patents in general, and sort of and the Industrial Revolution. So were patents an engine of development, or were they a brake? And I don't know that if that sort of conclusion is obvious from your presentation already, but it seems that sort of what the modified patent system does is make information more accessible and in a way sort of less protected. And that someone might draw the inference that then patents have been a brake to economic development, at least in a certain way. So do you have any sort of general inference about the role of patents in the Industrial Revolution? Were they sort of on the whole a positive thing, or were they on the whole maybe not a positive thing?
Yeah, I definitely think they were on the whole positive. Remember, the disclosure, you get something in return, which is 14 years of monopoly. And there are, of course, cases in which patentees claimed that they were not able to recoup their expenses in that 14 years and sought extensions and so forth and so on. But on average, 14 years of monopoly is pretty good, especially for something like Churchman's chocolate manufactory, which I think eventually got bought up by Cadwell's. So those sorts of stories would have, turned into the buyer's remorse incentives to bring in new generations of inventors on the incentive side. But the revelation side is, I think, just a net positive for all those sort of Republic of Letters and open science and open coding and whatnot reasons. And that's what I think is the catalytic agent. It's, I imagine all of us in this room as a community of scholars, and none of us communicate with either of us, and that's the status quo. And then a reform comes in where the director requires us all to reveal our, findings and publish them in some form, and maybe file pre-registration plans and all kinds the usual sorts of things. And all of a sudden we find out that there's a constellation of us that can solve problems now that we have access to more information. Whereas previously we were spinning our wheels on the same, with a few key assumptions ingrained in our isolated and autarkic research processes. So it's breaking down autarky, exploiting complementarity. And I think that potentially can be very potent. Whether how potent it was in the 18th century, it's very hard to quantify.
Right. So far, your story is about supply side of inventions and innovations. We know necessity is the mother of inventions. I wonder whether you have any view on the demand side. Although of course inventions and innovations can sort of predict future returns, but still, from your curve, enough people predict they get some returns. So what's the market like? The demand side looks like.
Yeah, so I have two sort of ideas there, neither one of which the paper provides any new evidence for, but both of them I think have some value. So the first one is just Smithian specialization and sort of ordinary economic history of 18th century England. So what does that mean? It means that if we believe that process of Smithian specialization is occurring and that the English market is widening and integrating through the Turnpike Road and the canal system and so forth, then essentially the value of any invention, even the patent medicines, goes up substantially, because not only can I sell my patent medicine in Bristol where I've invented it, but I can now ship it economically to a wider array of England. Perhaps I can advertise it more cheaply. If you've read 18th century English newspapers, you see they are filled with patent medicine advertisements, not just in London. So specialization and expansion of the market simply raises potential profit level, and this induces invention. Whether or not it induces patenting is still unclear because the patenting is so expensive. If you add to that the complementarity point, you get that's more on the supply, but the demand is driven by all this specialization. The other demand story is Alan's about coal and wages. And I mentioned that in the paper, and I attempt to control for it in my analyses. I include coal as a predictor of patent rates, and it works in my analyses. But even controlling for that sort of demand side factor, the disclosure effect is still pretty much the same.
What was the percentage between single inventors and one invention versus multiple inventors or multiple inventions and one inventor?
I'm going to guess at the percentages. So the percent is 90% single in 1660 all through to the Glorious Revolution. The revolution does have a noticeable impact. I didn't put this in the paper, but if you look at the patent records tell you whether you're a lord, esquire, a mister, so forth. So you can categorize by high titles of nobility down to, I think I go down to esquire and below. And there's a sharp discontinuity in 1689. Prior to 1689, you've got to be the king's cousin or something like that to be thinking about this patent. Afterwards, you get a significant increase in the number of low people, mere misters or sirs and things like that. Or no, actually, no, sirs is a higher one. So there's that. After 1689, though, we still get not a lot more doubles. So I'd say the single patentee percentage is probably still around 90%. And then after 1734, it begins to go up. It's going up, I should say, before that percent. If you sort of average it and run it on an average, that's already trending up. So there's already some evidence of somebody having the idea that, I'm not just going to patent once. Presumably, some of these single patentees are being inventive in other ways and just not patenting it, but we don't have that in the data.
So just a clarification question that may be based on misunderstanding. The reform of 1734 requires disclosure of technical specifications. But in exchange for that, is the person that receives the patent given a longer period of monopoly control over the patent? So the 14 years is staying constant?
Yep.
The only thing that's changing is, okay.
In the technical specification, that sometimes they would be revelatory and sometimes they would be purposefully obfuscatory. Presumably the beneficial disclosure effect will be very much frustrated when they're obfuscatory. What is it that determines whether or not the particular patent, the technical specification of it, tended to be obfuscatory or revelatory? Because as far as I understand it now, and correct me if I'm wrong, a lot of the kind of biggest high value patents that people like Apple and Microsoft do, they patent a very broad perimeter around the actual technology that they want to use, for that precise reason, so that people can't innovate in a way that might compete with them. So what lesson might be learned from trying to stop them from doing that?
So the patent literature on the 18th century, again, has most of the modern tricks, I would say, and certainly that one. So at the level of a narrative history or an anecdote, somebody will describe such and such an invention and the specification and say that they were purposely trying to carve out as large an area as possible to defend. And the pushback on that is that if your specification was not revelatory enough, then it could be voided. And there were, going back to 1731-2, there were cases in which patents were voided because the specification didn't tell anybody anything. So patentees were playing a game as to what would the courts think. So Watt is a famous example where there's a long debate about, so he has a very clear but principled and non-detailed description of his steam engine. So he clearly explains the principle of a separate condenser, but manages to slide over some details that engineers might very much want to know. And that patent, of course, was valid and defended in the courts and then extended. And then there's this debate about whether Watt was a net drag, sort of going back to an earlier question, because he got such a long period of patent protection, and the claim is that he prevented further improvement on the steam engine. In particular, these Cornish steam engineers busily working away on new designs were discouraged from pursuing their ideas, or had to hide them and secret them in order to avoid prosecution. So I guess I've sort of segued off into my view on that particular one is that there's plenty of ammo on both sides, and the relevant counterfactual to me is not whether Watt tried to prevent others from innovating. He certainly did. It's what would the state of play have been had he never patented and never divulged and kept the separate condenser as a trade secret, which would have been a very typical way of proceeding in 1600, still a very typical way in 1650, still a really typical way in 1700, and was still being tried well into the 18th century and into the 19th century and even today. So the revelation of an important principle, I think, can be extremely valuable. And one way I read all the Cornish steam engineers who he was trying to stop is they had all figured out something that he hadn't, based on the principles that had been very clearly explained in his document and might otherwise not have been.
Could we go to the next graph, the one where it shows the kind of difference between London and the rest of the country? Oh, sorry, I didn't realise. I thought it was like 2 ahead. There we go. What's the story after about 1800? Because you mentioned the journals, Nicholson's journal, you've got Tilloch's Repository of Arts, you've got Ackerman's journal. They're all around 1796, 7, 8. Given those publications, do you actually post-1800 see a fall in London's advantage? Because presumably those publications make suddenly the really useful specifications freely available to pretty much anyone.
Not a great deal. And so if you compare it to Birmingham, yes. But if you compare it to all England, including all the rurals, but I haven't looked at that perhaps as carefully as I should have. A couple of things I can tell you is that although the journals were republishing specifications, in many cases it was an abridged version. And so the claim has been made by, I'm blanking on the name, that if you really wanted the details, for example, like Louis Paul's second patent, even in the 1750s, had 40 folios of technical support. And so a lot of these expensive specifications have a lot of background. And so what was being reprinted was the abstract. That could be very useful from the perspective of principles, communicating new technical possibilities, but perhaps not give you the full value. So there would still be some London value.
It'd be interesting to see if it does decline a bit, because the journals are run by inventors as well.
Yeah. Well, the other thing that's happening is eventually there's railways, and so the cost of traveling to London goes down substantially. I think also patent agency by this time. So Bolton just writes to his agent in London and asks for a specification to be sent up. And so presumably various inventors, at least well-heeled inventors and well-informed inventors, don't suffer particularly relative to their London colleagues. However, a poorer, less well-informed, but brilliant young inventor still would be better off if they happen to live in Westminster than if they happen to live in Durham or something.
Is there any evidence that this depressed certain types of invention? If the number of years that you get to control the monopoly for is fixed and doesn't change, but you are required to disclose details of the technical specification, I would think that that could create situations where people would be discouraged from actually filing for certain patents and for inventing, because they are essentially being required to release information that competitors could use to generate rival products.
So another theme in this literature is that important inventors avoided the patenting system. But they don't make that argument. The argument is typically the patent system was so ruinously expensive, and it was to get one to begin with, and it was so fraught in order to defend your rights that many important inventors, not all, but many, just said to heck with it. And they therefore opted for secrecy. I like your story better. Wilkinson, for example, who invented the precision machine tooling of a cylinder, didn't patent. He just kept it secret and profited substantially. I think in his case, he might even have got out a pen and pencil probability that I can keep this secret for at least 14 years. And I think that would be a pretty easy one to do in his case. He didn't have a large work staff or many machines, and he could lock them up and all that kind of stuff. But yes, I mean that would be an implication of this account, that certain kinds. In the broader literature, there's support for that style of thinking in what kinds of inventions do the Swiss specialize in, given that they don't have a patent system. And it's a bunch of areas where you can still profit by keeping your trade secrets secret. Ditto for the Dutch, who abandoned a patent system a bit before this time period. So there's already sort of cross-national studies that show this effect, that you force innovation into certain sectors when you lack intellectual property rights.
Okay, thank you very much, Gary. That's we've had a lot of very detailed questions there, and I think that's a comment on a really wonderful paper. So can we say thank you very much to Professor Gary Cox?